Call this special meeting of the Board of Adjustment to order. Can we have roll call, please?
John Moreland,
Here.
Owen Curley,
Here.
Alexi Gonzalez,
Here.
Jeff Trular,
Here.
Dan O'Malley, Todd Smith,
Here.
Jennifer Williams.
Here. Thank you. I don't believe we have any minutes to approve this meeting. On to correspondence.
You should have received an email from me on Friday or I think it was yesterday with correspondence from one of the condo associations, and then on the dais tonight is another letter that we received today.
Would that be read now or after the presentation of the new business item?
Did you take up the matter for deliberation?
We can't hear you. We can't hear you all.
So are you ready to proceed?
Yes.
Madam Chair, good evening, members of the board. Thank you all for making time in your schedules tonight to attend our special meeting. It has been called for the purpose of acting on the recommendation that was issued by the special magistrate appointed in the Section 1751 proceeding, which was initiated by Oceanfront at 10 LLC, a former applicant for a variance which this board denied. As may be evident by its reference, a Section 7051 proceeding is named for a section in the Florida statutes.
I'm sorry, Sandy. I'm so sorry. One moment. Do we need to disclose ex parte before this? The vice chair just brought that to my attention.
Well, this was just an opening to just tell you about the process. So you can do it now if you want, or you can wait until I'm finished and we actually put on the presentation, which is the substantive part of the proceeding.
So, please continue. Okay.
After since you were interrupted, I'm having a hard time hearing you.
Yes.
Even now?
Yes.
Okay. How about now? All right, so broadly speaking, a Section 7051 proceeding is a procedural opportunity for an owner who believes that a development order is unreasonable or unfairly burdens his or her property to pursue a mediated resolution with the governmental entity that issued the order. In order to initiate the 7051 process in Jacksonville Beach, the owner sends a request for relief to the mayor. And within a defined period of time after receiving that request, the city has a number of actions it has to undertake. The first is to notify adjacent property owners of the request and give them their opportunity to participate in the proceedings that will follow. The city next has to prepare a response to that request for relief. And lastly, with the owner, choose a special magistrate to preside over the mediation, conduct a hearing, and eventually prepare a recommendation relative to that request for relief. And in the case before you tonight, with the exception of actually conducting a hearing, all of those steps have been taken. It bears emphasizing that the special magistrate's recommendation is just that, a recommendation. It is not an order, nor does it carry the weight of law. By statute, it can be expressly accepted or rejected. If no action is taken with respect to that recommendation, by statute it is deemed rejected. And as the body that issued the development order that's subject to the recommendation, this Board of Adjustment is the body that takes the action or chooses not to act, as the case may be. Tonight's meeting was specially called to allow you sufficient time to consider the special magistrate's recommendation, and with that consideration determine whether action should be taken or not taken. For this particular proceeding, the city was represented by attorney Brenna Durden. Ms. Durden is a shareholder with the law firm of Lewis, Longman, Walker, and she will present on behalf of the city tonight, and she will answer questions on behalf of the city tonight. As we do not have these proceedings often, we do have a suggested order for tonight's meeting, and it's just a suggestion. We start with a brief summary and overview of the magistrate's recommendation. The city will then present relative to that recommendation, followed by the owner's presentation relative to the recommendation. Then we open the public hearing to receive public comment, and thereafter allow both the owner and the city an opportunity to rebut. Close the public hearing, and then the matter is taken up for further deliberation and action by the board, should that be deemed appropriate. So if there are no questions for me, and if there are no objections to the procedure or the order that I've suggested, I'll turn this over to Ms. Jordan for the substantive part of this presentation.
I have no objections to that order, but will you sort of cue us to make sure that we're, allowing all the parties the appropriate opportunities to speak, and that we're sort of abiding by what you've suggested?
Sure. In terms of the order, Ms. Jordan is going to have that. I think she's going to be navigating us through the meeting tonight. With respect to the time that's allotted to each side, I think we'll kind of follow the lead of the board in previous applications where the parties are given as much time as they need to present, and then only the members of the public would have their comments limited to a specific time frame. But Ms. Jordan is well aware of the order that I was going to suggest, and I'm here to aid her as she seems to need it. Thank you.
And given that this was a slightly different meeting format than our usual twice monthly meetings, I didn't open with our typical sort of statement of procedures. And I know that this is a little different, but I think it would still be appropriate to let the audience know the sort of opening salvo that we usually give at our regular meetings.
Yes, ma'am. And then I would suggest that after that, then it would be appropriate to deal with the ex parte communication.
Okay.
Thank you.
The Board of Adjustment meetings are quasi-judicial in nature. All decisions of the board will be based on competent, substantial evidence, including testimony provided in this meeting. Any person who is not an applicant or agent who wishes to speak will need to fill out a speaker's card located on the side table by the door and turn them into the clerk. Each member of the public will be given 3 minutes to speak on their item. Please refrain from speaking from the audience, and applause or cheering will not be allowed. Also, please silence your cell phones. And I had no ex parte communication on this agenda item.
I had a telephone conversation with Mr. Shore shortly after the magistrate issued an opinion wanting to meet with me. I told him that I prefer not to, and would just as soon hear everything I had to say as anybody else at the meeting tonight.
I've had that.
I received a similar phone call, and my response was I would not speak about this matter with the applicant, and that we would wait for the hearing.
I've had no ex parte.
I have had none.
I've had none.
I just wanted to check, as far as procedure tonight and so forth, I'm Lee Callison. I'm here representing the applicant, Oceanfront at 10th. I just wanted to check the format, the public, just what to expect tonight. First of all, we were told by the city that we did not need to submit anything for this evening. Then the city submitted an 11-page report basically saying you should not follow the recommendation of the special master. We were never given an opportunity to submit. We received their submittals, I believe Thursday evening. Friday morning is when I saw them for the first time, and I was out of town last weekend. So I guess I'm just here. Are we having this? Is this going to be consistent, like an appellate argument? If you're going to have them, you're going to have us. I just want to make sure I understand what the procedure is tonight. I just want to make sure we're on the same footing here as the city. And as far as the public, I have no objection to the public speaking, but I would appreciate the comments be limited to the report of the special master, which is what we're here to decide tonight. This event tonight, there's 3 things you can do. You can accept the report of the special master, you can modify the report of the special master, or you can reject the report of the special master. We're not here to redo the variance here. That's not what this whole thing's about. So I just want to clarify, what are we doing? When do we get to go? Why are they going first? We're the applicant. I mean, who's making these rules up? You know, what statutory authority do you have for how we're going to proceed tonight? And who's going to speak? Because I haven't been provided anything. And I just want to make sure we're going to run this meeting and we're going to get the same opportunity the city has, which I already feel like we've already been underhanded because they told us we were not allowed to speak to you. I don't know if anyone in the city spoke to you, but we weren't allowed to speak to you. You were told not to speak to us, and we were told not to submit anything. And then here we walk in tonight, and we've already gotten a 13-page report saying you should reject everything that a special master who was picked by the city said, you know, we don't want to follow that now. So I guess just before we start, I want to know what the ground rules are for my client and the applicant in this case.
I would defer to you as the board. I am the applicant. It's between the quasi-judicial board and the applicant. Candidly, I don't know what the city has to present beyond the scope of a staff report. And the reports have been filed, the special magistrates report's been filed, and in terms of a variance, this is special because they called a special hearing to give us both adequate time to present and listen to one another to try to resolve this. It's not special unless incorporate another set of rules. I've never been to a variance hearing where the city presented, pleaded, and then opened it up to the applicant. It just, the process doesn't, it seems skewed, and there's been multiple events of that, and I would just want a fair and impartial process. I don't know, is it ex parte when the city officials talk to you guys, but we can't talk to you? So those are questions that go in our mind, and so let's just be totally open kimono and let's talk about it. And
I mean, at the hearing, we asked to have members of you speak. We asked to have city officials speak. They refused to provide it. They said that you're all government officials and we have no right to subpoena you. And they're right. We didn't have a right to subpoena you. We asked the special master. They objected. So we've been cut off from all communication, and they've cut you off from any communication with the special master. And I'm just concerned about, you know, the way this process is being controlled. All we want is a fair hearing.
Are you the special master?
No, I'm the attorney that represented them at the hearing with the special master. And we object to their characterization that there wasn't a hearing.
Was it your intention to submit something in writing?
My intention tonight is really just to go over the special master's report and the statute at issue in this case and make sure, or try to educate, or make sure you all understand what it is we're here to do. I mean, the city's already given you their, report and recommendation. I guess they're going to get up and argue it on top of supplying.
I know every case that comes before us, and this is, I know, the first time that I think most people on the board have experienced this specific type of hearing, but every time that we hear a variance, the city prepares a staff report outlining just all of the criteria by which we're supposed to judge each application, and we are always provided with those prior to the meeting, and then the applicant is always permitted to, give their testimony on their item, and then we do open it up for public comment, and we limit each public speaker to 3 minutes. I'm only going through this because you asked what the typical procedure is.
I appreciate it very much.
The applicant is then usually given an opportunity to address any of the public comments made, and then the board's also given, typically the board asks questions, if the board has any questions of the applicant, they take that time to ask those questions. Now, I would defer to our city attorney on the item of whether this I think really what we're supposed to be doing here is deciding on the special magistrate's decision, not having the variance.
Yeah, I don't want to rehear the variance. The special master, if you've read his report, he went through and piece by piece went through that staff report. That they submitted a 78-page report to the special magistrate of everything in this case, and the special magistrate considered it and made his decision, and he made his ruling. And I think we're here today basically to rehear this special master report. We've already had the special master report. We're here tonight to to determine whether to accept it, modify it, or reject it. So what is the city arguing?
I'd like for our city attorney to speak on that.
The essence of the argument so far by the applicant is the order that we've suggested to this body tonight. The city has no objection to the applicant going first and representing whatever it feels is necessary to get this board to act relative to the recommendation. But everything else that we suggested here conforms to our normal process. We've been upfront with what our process is, what our recommendation will be, and we are prepared to be limited to that discussion, but you should be afforded the opportunity to have that information presented to you in a way that aids you in your decision as to whether you will take some type of action. Thank you.
I do have a quick question. Since the applicant is the move-in, isn't it correct to allow them to go first?
Well, as I just represented, sir, we have no objection to them going first. We really don't.
I would add that should we go across the board and answer to ex parte communications with the city? I mean, that was one of the
Good point.
questions you raised.
Yeah.
I would appreciate
We
that.
appreciate that, please.
Just as an FYI, talking to city staff is not ex parte communication. We're here to provide support to the board. And just a quick point, technically speaking in the code, we are required by the code to present both written and oral reports to this board. We haven't typically done oral reports, but the code does specify that we have the opportunity to speak as well on these items. So that is procedure.
Madam Chair, our attorney also would like to basically address one of the representations that was made by the applicant in his statements to this board. So I'll turn it over to her. Thank you.
May I add? I can for just 1 second.
Yes.
Typically, we swear everybody in who's going to give testimony.
That is correct, and thank you. I didn't want to interrupt, but I think it would be appropriate for anybody beyond Sandy who speaks going forward to be sworn in by the clerk.
Please raise your right hand.
Do you want everybody who's going to speak at one time, or what? Each?
No, each person will be sworn in individually.
That's exciting.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address or position.
For the record, good evening. I'm Brenna Durden. I'm with the law firm of Lewis, Longman and Walker. Can you hear me?
If you wouldn't mind waiting until whoever in the audience could silence their cell phone, please.
Trying to throw.
All right, please continue.
Okay, thank you. Brenna Durden, I'm with the law firm of Lewis, Longman and Walker. I'm here tonight representing the city of Jacksonville Beach in this special proceeding. I do want to correct a statement that was made by Mr. Kellison. I actually have the email that I wrote to Joe on June the 2nd. And in that, I'm going to read you the whole thing. It says, "Hi Joe, it is my understanding that the BOA will take up the reconsideration of the variance request at a special meeting on July the 12th at 5:30 p.m., subject only to the quorum requirement." The reason that part's in there is because I don't think Christian knew yet whether each of you would be available on July 12th. You are not required to submit anything, although you may if you wish, but no new application fee or other costs will be required to be paid. At that time, the BOA may make a determination to accept the SM, the Special Magistrate's recommendation, and approve the variance. They can reject the recommendation and confirm the denial of the variance, or they could choose to approve the variance with conditions. And then I close. So it's, I want to tell you that at no time did I tell them that they could not submit anything for this hearing. And I take issue that that would be represented to this board improperly and incorrectly. Thank you.
If I have the consensus of the board, is everybody okay if we allow the applicant to present first?
Great.
Okay.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and your address for the record.
My name is Lee Kellison. I am an attorney for applicant Oceanfront 10th. My address is 599 Atlantic Boulevard, Suite 4, Atlantic Beach, Florida. Let me just thank everyone for coming tonight on this special meeting. I appreciate your time. As you're all aware, we're here to address the report of the special master that was issued pursuant to Section 70.51 of the Florida statutes. As you're also aware, there was previously an application that was considered by the board. There was a lot of debate about it. A lot of people from the public came. There was a 3-2 decision against the applicant. They exercised their rights under the statute for a dispute resolution, and we had a special hearing before a special master. And you all have a copy of that special master's report. So I just want to start off by giving you a couple of things to make sure that everyone has this. It may not have time to look at it or not, but I just thought that this would be perhaps of some value to the board during the hearing tonight. I just have a copy of this statute.
Everything can be submitted through the clerk and she'll distribute, so.
I have copies of them. 6. Okay, there's several copies.
Will you have a copy?
Well, I brought 7 copies. Thank you. Copies. The other thing is just Terry's CD, so that got off his, Terry Schmidt.
Oh, I'll take them.
We're probably talking a lot tonight about this statute. I'm going to make reference to it, so I just wanted to make sure that you all had a copy of it. The other item that I provided to you is just a CV of the special master, Terry Schmidt. Terry Schmidt has done multiple hearings as a special master for the city of Jacksonville Beach. The city recommended Terry Schmidt. My client agreed with Terry. He's a very, very well-respected attorney. As you can see from his CV, he has been practicing since, I believe, 1973. He has been in Best Lawyers in America. He's been in Super Lawyers. He indicated to me that in addition to being a special master for the city of Jacksonville Beach, he is quite frequently, or I say that 4 or 5 times, has been a special master in hearings for the city of St. Augustine. And he's also performed a couple other hearings around the state as a special master. So he has substantial experience as a special master. He's also an arbitrator, and he's a mediator. He's probably one of the top 5 mediators in Jacksonville. He mediates all kinds of disputes all the time. You have his resume in front of you. He says in there he's mediated more than 5,000 cases in state and federal courts over the past 25 years. He's got experience in all different areas of the law. He's a very personable man, and he's very, very well respected in the legal community. He was the one that was the special master in this case. So, as noted by that statute, in paragraph 17 of 70.51, it talks about a hearing before a special master. It says, in all respects, the hearing must be informal. It goes on to say that the hearing must operate at the direction and the supervision of the special magistrate, Mr. Schmidt. And what is supposed to happen at that hearing is initially, they're supposed to try to facilitate a resolution to the conflict, commonly called mediation. We tried to mediate this dispute. It's in the report. We made a couple of different recommendations to the city. We could never reach an agreement. So then when you can't reach an agreement, the special master is supposed to consider the facts and circumstances set forth in the request for relief and any responses and any other information produced at the hearing in order to determine whether the action by the governmental entity is unreasonable and unfairly burdens the property. That's exactly what we had here. We submitted a couple-page report. As I stated, the city submitted a 78-page report, that's with exhibits, to the special master, outlining their position in this case. The said special master received that. He heard from everyone at the hearing. We kind of broke up and did it informally in mediation in breakout rooms, but he spent at least 3 hours, if not longer, with each of us. We all had a chance to tell them our positions in the case. And after he hears from all parties, if you look at paragraph 18 of section 70.51, it talks about the circumstances that the special master is supposed to determine. And it includes the history of the property, the history of the development or use of the property, the history of environmental protections, the present nature, the reasonable expectations of the owner. And then specifically in F, under 18F, it talks about he's supposed to decide what the public purpose sought to be achieved by the development order or enforcement action is. And then lastly, he is instructed to consider uses authorized for and restrictions placed on similar properties. So this is what the statute required Mr. Schmidt to do, and that's exactly what he did. And then if you go down to paragraph 21 of the statutes, it talks about what the board here tonight can do. And 21A is you can accept the recommendation of the special magistrate as submitted and proceed to implement. And that's what we're going to ask you to do at the end of this hearing tonight. Secondly, you can modify the recommendation. Or thirdly, you can reject the modification. And then it says in paragraph 25, regardless of the action the government entity takes on the special magistrate's recommendation, a recommendation that the development order or enforcement action, or the development order or enforcement action in combination with other regulatory actions is unreasonable or unfairly burdens the use of the owner's real property may serve as an indication of sufficient hardship to support modification or variances. Now, in that report, the special master did find that the denial of the variance unreasonably and unfairly burdened the property of Oceanfront at 10th LLC's property. Again, we're requesting that the board tonight approve that recommendation. At the hearing itself, it was held on May 9th. It was an informal hearing, as I stated. We all got together. We broke out. We had mediation. I don't know if any of you ever participated in mediation, but the way Mr. Schmidt works, and he takes a lot of time with the parties, breaks you out in a room. He'll go sit with you for that first meeting, probably an hour, goes over everything in the case, what your position is. And then he goes to the other side, he presents it to them. He listens to their position, and they present it, probably for a good hour or so. And he brings them back, he tries to find middle ground. But in the process, he learns exactly what each party's position is on the issues. And that's exactly what he did in this case. He went back and forth multiple times over at least 6 hours, if not longer. We got here that morning, I don't remember what time we started, but we didn't leave till about 6 o'clock at night. It was a full day. And he had ample opportunity to listen to everyone. As I mentioned, both sides submitted written reports to him before the special hearing. He attempted to mediate. Nobody from the city, and I've spoken to Mr. Schmidt, nobody asked him to stay later when he said he was terminating the hearing. After the hearing, he corresponded with Ms. Durden, myself, Joe Van Roy, one of the owners of the applicant. He's also an attorney. And Ms. Robinson, he's corresponded with all of us. He had numerous questions. Both parties tried to answer his questions, submitted more documentation. There was at least 10 emails from him asking for information that both parties responded to. After the hearing, and after considering all this information, and we know from his bills that he spent 50 hours reviewing this matter. And if you read his report, and I sure hope you have, he goes in painstakingly detail over every issue raised by the city, every issue raised by the owner. And he would accept or reject them. And the end of it was that he gave a very well-reasoned report and recommendation. His report is an objective review of the evidence in this case. It's not our opinion. It's not the city's opinion. It's an independent person who's done this multiple times, who has a ton of experience, who gave his review of whether the variance unfairly and unreasonably burdened the property, and he said that he did. And so I just want to highlight for you just a few of the things in the special master's report. Some of the pertinent findings of fact. Number 8 in the report. The variance request did not change anything about the property or the building being constructed. Number 9. The building will have the exact same footprint, the exact same design, and the exact same construction, whether it's built as a condo or a townhouse. And then number 10, he found the fact that the approval of the variance request would have no effect other than to allow the applicant to sell the property as townhomes versus proposed condos. As stated in that report, he reviewed the original application from my client Oceanfront. He reviewed the city's staff analysis report that was presented to you all before the original variance hearing. He watched the hearing. He actually watched the hearing on YouTube. He considered the testimony of the public and the contiguous landowners. He considered the owner's position as set forth in our application, and he considered the city's position as set forth in their opposition. Then he made several conclusions, which I want to point out to the board tonight. Number 1, granting the requested variance would not physically alter the building in any material respect or adversely affect the city, the neighborhood, or any objector in any material respect. The legal effect of the board having granted similar variances to townhomes and individual homes across the street from where this oceanfront is was troubling to the special master. He specifically concluded that the city of Jacksonville Beach and this board should have given considerations to these variances that were previously granted. The special master in his conclusion stated that he only considered objective factors presented by the parties. He also concluded that the owner met all of the requirements for a variance under the code, section 34.286. I know the city has said that we didn't meet 5 of the 6 criteria. the special master in painstaking detail refuted every one of their arguments that we didn't. And he has concluded that we did meet all of the requirements. And then finally, the special master determined that the public interest will be fully served by the approval of the owner's request for variance, because there will be no material difference between the building constructed as a townhouse development or as a condominium. And the city should have no greater right to compel the owner to construct and sell the units as condominium units under the unique facts of this case than it would have if the property were sufficient width to permit the owner to build either a condominium or a townhome development. Essentially, the special master decided that a variance is appropriate in this case. Now, I don't know if we're going to come back up, but I'm just going to make a couple quick points. The city did submit a report and recommended that you reject the special master's report. First of all, they said that it doesn't carry any precedential value or weight. Well, I guess that's, again, a matter of interpretation, because, as I stated earlier, that if you all don't say a recommendation under number 25, a recommendation that development order is unreasonable and unfairly burdens use, it may serve as an indication of sufficient hardship. So I would submit to you that it does have precedential weight and value. The city of Jacksonville Beach also says that the special master disregarded section 70.51 and the code. As I stated, you can read his report. He explained every step he took in this case. It's a 23-page report, and he cites the statute and what he's required to do and how he met those conditions. And I don't see anywhere where he exceeded any authority. Then they take issue that he considered variances of property across the street. They claim that there's too old to consider. There was also a 2009 variance that the city failed to mention in their report. But regardless, as I mentioned earlier, section 70.5118F explicitly requires the special master to consider uses authorized for and restrictions placed on similar property. He is required by statute to look at other variances on similar properties. That's exactly what he did. They're taking issue with him following the statutes. Another thing that the city disagreed with in his report is that they're saying the shape of the lot can't be a special condition. The special master found that the fact that it's a narrow lot constitutes a special condition. I would just remind this board that at that meeting on the January 19th, there was 4 variance requests that were all approved by the board. One of them was by the Van Meters. In the specific minutes, it says the hardship was a non-conforming lot size. Variance approved. If you look at BA 21-100-186, Colin Spetz, hardship was a non-conforming lot. Variance approved. If you look at the Graham's application for variance, 100-187, hardship was a non-conforming lot. Variance approved. And the last one, if you look at Los Ganos, 21-100-190, the hardship was the odd-shaped lot. Variance approved. We have a narrow lot. For some reason, all these other applicants have odd-shaped lots, non-conforming lot size. They all get variances. Our narrow lot, under their reading, isn't entitled to a variance. It's not consistent. One of the other things that they argued to the special master was that we shouldn't be granted a variance because we could build 3 townhomes on that existing site. Well, if we had to build 3 townhomes on that site, they would be 15 feet wide, lined up, really long units. The middle one wouldn't even have windows. And the special master, I'm just going to read exactly what he said. He said, the 3 townhouse alternatives suggested by the city staff several times in his report is neither feasible nor a reasonable or practical use of the owner's property. And then lastly, they said that special master terminated the process, that we didn't have a hearing. As I've already told you, he met with us each for in excess of 3 hours, did follow-up, considered all these reports. The process by statute is supposed to be informal, and it is to operate at the discretion and supervision of the special master. And if he decided that he had enough information from meeting with the parties to make a ruling, then that's what the statute requires. There's absolutely no basis for the statement that he didn't comply with that statute. So, as I stated already, the special master's report is a well-reasoned opinion based on an objective review of the evidence. Every issue that's in the staff report from January was considered and rejected by the special master. The city today is asking you to reconsider that staff report from January 19th. That staff report, I might add, that they acknowledged at the hearing had an error in it. And then they're here in their report asking you to reconsider that, because the error was that even they granted the variance to be a non-conforming lot. That's false. We're concerned that negatively infected the original hearing, and we think the special master thought so too, because he specifically cited this in his report. So, in summary, approving this variance would have no impact on the city of Jacksonville or any neighboring property. We're here requesting you to accept the report of the special master and grant the variance from the applicant. And I thank you all for your time, and the owner of the property may like to say 1 or 2 words.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address for the record.
Richard Johnston. I'm the applicant under oceanfront tenant. Thank you for your time this evening. Appreciate you guys taking time out of your schedule. I find myself in a very unique position with this particular variance, having come before this board on numerous occasions and executed several successful projects and variances. So I'm somewhat befuddled with the process, and really hope that we can find some even footing. Personally, I can't help but think that there's been a lot of influence as it relates to this variance. The city has been against it from the offset, and I think the thing that's so troubling for me is never have I had to work so hard when nothing was going to change, except the title of the land, no physical characteristics of it. We went through an extensive variance process. We applied to the special magistrate through the city. It seems like at every turn we've been not able to get what we wanted to. It was my intent to establish ex-parte communication with each one of you. I wanted to get this report in your hand because I felt like we were getting shaded, and a couple issues I would like to go back to. The staff report that came out before the initial variance hearing, it was issued out on a Friday before Martin Luther King Day, and then it was the variance. It was also the first time in forever, as far back as I could see, where the staff reports included recommendations of approval and denial. I know the subsequent hearings have included that, but that was the first one. So I went back and I've looked. There were some erroneous facts that were contained in it. Mr. Kellison alluded to the staff report included reference that the lots would be immediately non-conforming. Christian, based on questioning by you, Ms. Gonzalez, he did some figuring and he spoke up, but it was kind of towards the end of the hearing, and candidly, that was a fatigued hearing. There was a lot of public comment. It was late. We spent a lot of time on it. So, watching those things transpire, and then on the heels of, maybe Ms. Durden didn't say no, you can't file anything, but it was sort of like, I was copied on the thread, and I sent to my counsel, like, something's up. That seems weird. She's going on vacation, but we don't need to file anything. Then we talked amongst ourselves and said, okay, yeah, let's get the report in your hands. Because I don't know when you guys got the report from the special magistrate. We never got to follow up on who's had ex-parte communication with Sandra or Brenna, or where do you draw the line? When Mr. Moreland and I are respecting their position and having the opportunity to be able to call on you from time to time for advice regarding this process, when you informed me that you were told by Senator Robinson not to speak to me, that was troubling. So much so that I asked Mr. Van Roy to send an email to Sandra to verify, did you in fact tell the board not to speak? And she said, yes, I did. And I think the concerning thing is that we seem to be coming from behind the 8 ball at all times, and we're trying to put our best foot forward and give you the information, but we're not being able to do so. And I can only assume that Ms. Robinson used this term when she spoke with you, Mr. Moreland, that, my mischaracterization of the word award was why she instructed you to not speak with me. And that's just weird that we can't, do we email you? How do we contact you? How do we give you information prior to when they're controlling the spigot of how you receive the information, how it's disseminated, and how it's presented? Those are real-time questions, and based on the sequence of events and how things have went down, I feel like, I want to get back on level footing where everybody knows what's happening. We don't know the amount of communication. We don't know what's been given back. But he responded to Ms. Robinson, and he sent back this email, which Ms. Robinson is copied on, as well as everybody else, from Terry Schmidt, where he refers to a final award, no less than 6 times in one paragraph. So it was called an award the whole way through because that's what the man who administered the process called it. So that's the issue was the variance, and now the issue is the special magistrates report. A ton of effort went into it. When Mr. Kellison says that the special magistrate did more work afterwards, he did. I mean, a couple weeks from the time the hearing went down until he issued the report, and he asked the parties questions: building size, footprint, talk about your alternate scenario. It was a lot of work went into it after the fact, so it was clear deliberation. The quality and content of his report, that he didn't fake his way through that. They were hard conclusions that he came to from an objective standpoint. I don't understand the interface with the board and, I know there's a liaison, but I thought it's an autonomous quasi-process. I've always interpreted it as such, and I would, like to be able to continue to consider it the same way. We'd like to have this variance approved. We've met all the conditions as found by the special magistrate. The project's being built, nothing materially changes about it whatsoever. It unlocks entitlements that we're entitled to based on the underlying land use and zoning. The variance that we're asking for is less than those around us in surrounding properties. And candidly, I'd like to put this chapter, behind myself and allow my project to move forward and get the stigma off of it, and hopefully, start to rebuild relations with city staff, because it makes no sense. Like I said, I've never had to work so hard to not accomplish any movement or coverage or anything. So with that being said, I appreciate your time, and I would ask that you consider the special magistrate's report and vote to approve it this evening. Thank you.
Not to clarify anything. What I said to you on the phone was that I talked with Ms. Robinson, who had said she recommended that I not talk with you, but the decision was completely mine to make. And I then followed up and said that I had decided that I was not going to talk with you at that time.
Sure.
Well, we did discuss it today already. Okay, anything else from the applicant before we move on to the
Not at this time, but we would like to reserve, things to
for it ahead of time before I start croaking. Thank you so much. Brenna Durden, Louis Longman and Walker. My address is 245 Riverside Avenue, Suite 510, Jacksonville, Florida. And I'm here tonight as special counsel on behalf of the city of Jacksonville Beach. And I'm honored to be allowed to do that. As you've heard, we are here tonight to decide whether to accept or reject the special magistrate's report and recommendation. As you know from reading the staff report, the staff recommends that the board reject the report because your decision to deny the variance on January 19, 2022 was reasonable and does not unfairly burden the owner's use of the property. As you know, Oceanfront submitted its building plans for a 5-unit condominium project. The city issued a building permit for that project, and that project met all of the land development code requirements, including all of the setback requirements. Construction, as you likely know, is certainly underway at this point. However, shortly after the issuance of the building permit, and construction was already underway, Oceanfront filed a request for 2 variances to reduce the front yard and the rear yard setbacks. The need for those variances arose because Oceanfront desired to develop the 5 townhouses rather than the condominiums that they had obtained the building permit for. Contrary to Oceanfront's position, that change, this proposed change, constituted a change in use. That is the crux of why the changes were necessary, that we ended up with different building setbacks for a townhouse versus a condominium. It is a different use. It's one that results in significant impacts and changes under our city's code as well as under various Florida codes, such as building codes, fire codes, emergency 911 code, address issues. And the one code relevant to us tonight is the land development code. Townhouse development is different, is a different use from condominium development, and it's treated differently in our land development code. This is not an unusual in any sense. In fact, it's universally recognized that different types of uses will be and are regulated differently. For example, and relevant to today's hearing, in the context of residential uses, it's not uncommon to find single families, duplexes, quadruplexes, townhouses, multifamily and condominium uses to be regulated differently. Sometimes regulations may differ based on the density. They may differ based on the height. They may even be based on differences in location. In our land development codes are no different than these other common practices, not only throughout the state of Florida, but throughout the United States. Oceanfront's desire to change the use from a condominium development to a townhouse development ended up triggering a different set of regulations that would apply to the project. Why does our code do that? The reason is that the proposed townhouses, that the lot size for a proposed townhouse is different than the lot size for a condominium project. In a condominium project, the lot size is the entire area of the condominium project. That is the lot size. That is the parcel. There is no breaking up lot that Oceanfront owns. It is, under the condominium project, the lot. But in a townhouse development, each townhouse unit carries its own separate lot. And as you might expect, that is going to be a much smaller lot. When the setback regulations, which by the way are actually the same for multifamily as for townhouses, when they were applied to the individual lots, each townhouse, because he'd already started construction, could not meet the setbacks that are set out in our code. And as a result, there was a need for these variances. Moreover, our code treats the oceanfront parcels differently than it treats inland parcels, in that regardless of what direction the front of the building faces, of a residence may face, under our code for multifamily, the ocean side is always going to be the rear yard. That's not the case for townhouse development. For the condominium project, this aspect did not create a compliance issue, but for the townhouse project, it does, and it did. In our city, the provisions and criteria on which a decision by you for or against a variance are set forth very clearly in section 34-286. It's the applicant's burden to come to you to show by competent substantial evidence why the circumstances and the conditions of their particular application meet those 6 criteria. As you know, a properly noticed hearing before this board was held on January 19th of 2022. And at that hearing, the applicant provided testimonial evidence as well as documentary evidence that he made a business decision to apply for and commence construction of a condo project and to time the application for the variances for some time after construction began. The applicant further testified that the reason he wanted to do this and he wanted to convert the project to townhouses was to avoid various aspects of condo development, namely the regulations and the filings required by the state law and alleged higher insurance premiums and financing difficulties that prospective purchasers may experience. Members of the public spoke both for and against the variance requests. You voted to deny the 2 requests, basing your decision on criteria number 2, that the applicant's failure to show that the need for the variances was not the result of the applicant's own actions. In other words, that the need that arose for the variances were the result of the applicant's own actions. As the staff report describes, the Special Magistrates Report attempts to establish that your decision was unreasonable and created an undue burden on oceanfront's property. But the basis for those conclusions is not reasonable in and of itself. For example, as noted in the July 7th staff report that you've received as part of the agenda packet for tonight, the report heavily relies on 2 similar variances, and I put quotation marks around the word similar. One from 1999 and another from 2005. I noticed that earlier there was a reference to a 2009 variance. The reason that, I believe, as I recall, that the reason that was not mentioned in the Special Magistrates Report is that there was conclusive evidence that that was not even a relevant variance to the topic at hand. Coming back to the variances that were approved in 1999 and 2005, I can tell you that I'm not sure that there's even a single soul in this city hall that was here in 1999. Save maybe, quite frankly, me. Not that I worked for the city, but I did counseled with the city quite a bit. 1999, I believe that your code has probably been modified 2, maybe 3, maybe 5 times since 1999 in some respect. And moreover, the criterion, when you actually look at the criterion, and this is why I think that the decision or the basis for the decision by Mr. Schmidt was not reasonable in this instance, is because when you actually look at that criterion, it is not whether any similar variances would have ever been granted, but rather whether without the variance, the owner would be deprived of rights commonly enjoyed by others in the same zoning district. It's inconceivable to me, as a land use lawyer, to believe that two variances granted 22 years ago in one instance and 17 years ago in another instance equate to rights that are commonly enjoyed by others in the same zoning district. Moreover, the report suggests that the owner will suffer an unnecessary and undue hardship if the provisions of the code prevent him from developing either townhouses or condominiums simply because both of those uses are permitted uses. Yes, it's true, both are permitted uses, but a landowner still has to meet the other provisions of the code. Taken to its illogical conclusion, if we were to accept the basis for that decision, the rationale and the reasoning behind that, it would probably preclude, in my opinion, nearly every other code provision that we have, save possibly the list of uses that are permitted. To say that because both uses are permitted, that any restriction against both those uses, that he should be allowed to do both regardless of whether a variance is necessary or not. By the way, I also heard earlier that statements about the other variances that this board approved that night on January 19th. Did you notice that many of them said that the lot was not conforming, that the lot was non-conforming? Guess what? This lot is conforming. It's 13,000 square feet. It's probably wider than most, and I can safely say that, it's wider than most lots in the RM2 zone in our city. Importantly, going back to the reasoning that was used by the special magistrate, that the RM2 zoning district allows both townhouses and condominiums. This also forms, in my opinion, the ill-conceived basis for stating that the lot's width constitutes a special condition peculiar to the property. Here, the report actually provides that the property is zoned RM2, which allows both uses, but cannot practically or economically be used for both. Well, first, I want to say that there was, I'll leave that. As a result, the special magistrate concludes that the width constitutes a special condition particular to the property, and which is not applicable to other parcels in the same RM2 zoning district. But of course, there is no question that simply because a parcel is not wide enough to accommodate a particular proposed number of units, or a size of units, or a type of a permitted use, this does not equate to a special circumstance that is peculiar to that particular parcel. In fact, as noted in the staff report, the July 7th staff report, that line of reasoning would effectively gut any meaningful effect of most of our land development regulations. The test is not whether an owner can practically or reasonably build any of the permitted uses that are listed in each of the zoning districts, nor as many as somebody might desire, but rather some special condition or circumstance that exists which is peculiar to this particular property and not applicable to others in that zoning district. Bringing this back to your decision tonight, given the circumstances of this case, clearly your decision that you made on January 19th was to deny the variance request was not unreasonable. Quite frankly, as reflected in the July 7th report, the request did not meet any of the criteria. Excuse me, I mean the January 19th report. The request did not meet any of the criteria, save the last, consistent with the comprehensive plan. I will say right now that on the record in January, the mistake that was in the staff report was corrected during that hearing. And again, it was noted during the proceeding, the mediation with Mr. Schmidt. Nor on January 19th did the applicant provide any testimony at the hearing to establish that it met any of those criteria. In fact, the testimony further emphasized that the request had only to do with the convenience and the cost to the applicant, all the result of the applicant's own actions, and nothing to do with the special circumstances or conditions that would be peculiar to that particular land, the building, or the structure. It is at all times reasonable for a public body like this board in a quasi-judicial proceeding to hear testimony and weigh that testimony in light of the specific criteria that is set forth in your governing documents. Indeed, in a quasi-judicial setting, that is the very essence of your function. And in that regards, the basis for your decision was not unreasonable. Nor can the denial possibly be considered an unfair burden to oceanfront's use of their property. There are numerous types of development that oceanfront can use its property for that do not require any setbacks. Moreover, the test is not, can you use it for townhouses or can you use it for condos? The test under your criterion is, are there reasonable uses for, and under the statute, are there reasonable uses that the landowner may make of his property? In this case, the fact could not be more evident. Namely, the reasonable use is the 5-unit condominium that the applicant himself requested, applied for, got the building permit, and is under construction. Clearly, there's a reasonable use in existence as we speak. By the way, the units are being advertised currently for well over $3 million apiece. Less than 2 years ago, Oceanfront purchased that property for $1.4 million. In my opinion, I believe that a return of 10 times or more can hardly be said to result in an unfair burden. The denial of the variances did not create an undue burden on the use of this property. Oceanfront could have chosen to develop townhouses if it had wanted to, or they could have chosen to construct more condominium units if they wanted to. In either of those cases, no variances would have been necessary. Both of these scenarios show options available to the oceanfront, to oceanfront. Certainly, there are other options. There's a long list of uses in the RM2 zoning district. The choice to apply for and begin construction of the condo project was made with full knowledge that a townhouse project with the same building footprint and would not meet the code requirements. You heard even tonight, Mr. Johnston describe himself as being a seasoned developer in this city. The cost to prepare and file condo documents required by Florida law do not create an undue burden on the use of his land. The request for a development plan and building permit approval for the condo project were voluntarily submitted with an understanding that the project could not comply with the setbacks for townhouses. Mr. Johnson has stated on the record that he fully intended to apply for variances after he started construction of the condo project, knowing that the condo project setbacks would not and did not comply with the setbacks for a townhouse. His reason, because of the administrative costs to comply with Florida condominium law, were too high. Yet in Florida, hundreds, probably realistically thousands of projects in Florida all abide by these same requirements: insurance, financing, statutory, and LDC regulations. Clearly, the desire to avoid those regulatory processes of preparing the documents and the administrative costs do not equate to an unfair burden. In conclusion, as I have described tonight, and is further described in the July 7th staff report, we believe that the special magistrate's report was improperly analyzed the criteria that are before you in making a decision. That is the main reason that we believe that you should reject that report, because of his reasoning is in our opinion, improper. And that he misconstrued several of the criteria when he was speaking directly to those criteria. There are, and we do, as noted in our July 7th report, we do believe that he did exceed the authority. He's, in one part of his report, he says that it does not take the place of a judicial decision, and yet he reweighed the evidence, which is improper even for a court to do. It's improper. So from that perspective, I do think that it's important for the record that you know that we believe that it was improper on his part to go that far. Finally, I do want to say that we recommend that you reject the special magistrate's report. In doing so, your decision from January 19, 2022 to deny the variances will remain undisturbed. I want to thank you for your attention and consideration of the staff recommendation. Thank you.
And based on Mr. Robinson's recommendation at the beginning of the meeting, since we've now heard the applicant's testimony as well as the city's, would it now be appropriate to open for public comment, or would you recommend that we ask questions first?
Of course, that decision is up to you and the board members, but I think in my opinion, I think it would be very appropriate for you to open up for public comment at this time, if you so wish.
So if we were to follow our usual procedure at this point, we would open to public comment, and then we would allow the applicant to address any of the comments made in public comment. Does anybody object to that? Okay.
I would just say that the city may wish to also respond to any particular comments in a rebuttal
Yes.
format. Thank you.
Thank you. As a reminder, each member of the public will be given 3 minutes to speak once we open the public hearing. And I will now open the public hearing. Do we have any speaker cards?
First speaker card is Bobby Welton.
And we will, we'll be using this clock, so please keep an eye on the clock so you know where your time is at, and you will also politely interject once you hit that 3-minute mark if you're still speaking.
Okay, but I will try to meet the 3-minute mark, but I may go over about 15 seconds or something.
And
I'm not going to be here for an hour.
You can be sworn in by the clerk.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address for the record.
My name is Bobby Welton. I live in the 100 block of 10th Avenue South, across the street from the developer. And I've lived there for 15 years.
Go ahead.
Okay. I'm not speaking here as an ignorant person about construction. I have a master's degree in business, and I've been in the high-end construction business, high-rise apartment buildings, office buildings, Ritz-Carlton hotels, et cetera, et cetera. So I understand the construction business, and I've been involved in mediation, arbitration, domestic lawsuits, and federal lawsuits within my years of construction experience. So I'm not speaking off the cuff here. The major point is that it was an excellent presentation by the assistant city attorney or whatever, representative of the city, and she was right on spot with much of what she said. The magistrate's report, first of all, the magistrate is not a judge, it's not a jury, it is just, he's a lawyer, and he was elevated to the position of a magistrate to be a mediator. This was mediation. Mediation is not binding. His job was to get the parties to come together to make a decision to end the dispute. He failed to do that. So for him to then create a report of his opinion of what happened is not really pertinent to this issue. It was only his opinion of the facts and his deliberation, which he failed to perform his job of being a mediator. So I think a lot of credit and legal mumbo-jumbo statements and talking about meetings and how long it lasted, that is immaterial. The material fact is that this developer misrepresented and basically lied about his intent, ultimate intent for the use of the property. He initially tried to get approval as a townhouse. It was rejected. Then he went and got approval, and then other approvals, variances, as a condominium. He started construction. Then what did he do? He totally misrepresented his intent and immediately filed for a townhouse variance. That's it's without dispute. And then he was repeatedly denied, according to the law and according to the ruling by the city committees and so forth. This is manipulation of the city. It is bait and switch. It is ill-founded, and it is misrepresented, and the city should not fall for this attempt to circumvent the laws, rules, and the zoning that have been established and have been in place for years. It should be denied and go back, just like she said, to the original decision. His intent was to build condos. He got approved for that, and it should remain a condo. That's my report.
Thank you. Can you call the next speaker, please?
Jessica Francine. Francina?
Yeah.
Sorry, is it Francina?
Yes.
I apologize.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address for the record.
Jessica Franzini, 1031 First Street South, number 808, Jacksonville Beach, Florida, 32250. Ladies and gentlemen, thank you kindly for allowing me to address this matter. My name is Jessica Franzini, and I am a board director of the Costa Verano Homeowners Association. I am objecting to this request for a variance on behalf of the 100 owners whose property lies immediately adjacent to 22 10th Avenue South. 100 owners whose combined property values are approximately $150 million, making us one of the largest taxpayers in Jacksonville Beach.
In your wisdom on January 19th, your board denied the request. We are only here today because the special magistrate has concluded that you were in error and should now approve it. That is opinion. You are the deciding body. We understand that your decision was a deliberate one, a decision that was based on information you had before you and the numerous objections stated by the neighbors surrounding 22 10th Avenue South. We have many reasons to object, but since you should have in your file a letter of objection written by our board president, in the interest of time, I will just cover what we feel is most important. Number one, changing the classification of the property from condominiums to townhome presents a huge public safety risk. Why? Because townhome developments are not subject to the recently enacted legislation which requires condominiums of at least 3 stories near the ocean to have periodical structural inspections and to fund reserves for structural repairs and other major required maintenance. We don't want a Surfside-type catastrophe in the Jacksonville beach. Number two, condominium statutes in general provide for more uniformity and a higher maintenance standard by requiring the association to insure the building and maintain common elements of the entire development. In a single-family townhome developments, each owner is responsible for insuring and maintaining their own individual townhome. Number three, the development is situated between 2 of the highest-priced condominiums in Jacksonville Beach, Costa, Verano, and Maribella. Rezoning the development as a townhome could negatively affect property values to owners of both associations. Number four, approval of the application will lead to other developers requesting similar variances in a similar manner. Number five, in our opinion, the variance application does not meet the required standards under the Land Development Code section 34-286 because the developer did not show that there were special or unique circumstances or that they would suffer any unnecessary hardship. Number six, in his report, the special magistrate states, I quote, "Frankly, the special magistrate was initially put off by the owner's decision to do a hybrid development by applying for a building permit only to change and then file for the variance. The special magistrate viewed this as a form of better to ask forgiveness than permission development approach." I ask you, is this the precedent you want to establish? That they act and then ask for forgiveness? Even though we respect the special magistrate's due diligence, we question his conclusions. Our biggest point of contention is when he states the objection by the objectors and the city that the townhomes might not be maintained as well as they would be if the building were condominium is purely speculative and borderline frivolous.
Ma'am, your 3 minutes are up,
Okay.
so if you could.
I'll just finish up. Okay. The special magistrate makes the assumption that because you pay $3 million, that they'll take care of the property. We, as the board of directors, say that's an assumption as well. Why are you assuming that they will take care of the property? If I could just conclude, is this how the Board of Adjustments wants to make decisions anyway? On assumptions that people will do the right thing? Or do you want to make decisions based on actual facts? Facts that have not changed. Facts that have helped you come to your initial conclusion. Facts that have been laid out before you today, found in your file, and facts that you are learning tonight. What was true before is still true now. The facts have not changed. On behalf of all the 100 owners of Costa Verano, we reiterate our strong objection to the request for relief, and we appreciate your consideration. Thanks.
Leah Terry?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address for the record.
My name is Leah Tahiri. I live at 1031 First Street South, number 907, Jacksonville Beach, 32250. So good evening, members of the Board of Planning and Development, and the attorneys for our city and concerned members of the audience. I come here today to oppose the grant of variance proposed by Dave Carr Investments LLC. When this property was purchased and when he decided to begin development, filing the appropriate paperwork with the city, the developer was informed that it could not be developed as townhouses, but could be developed as a condominium. He, as a professional in his field, recognized that this was a hard thing to do. He went ahead and filed for approval with the full intent of filing for a variance. His assumption was that it would be approved with little concern for the variance. As a request, are approved by the staff and take time and research and make the recommendation to the board for approval. I am puzzled by his failure to originally file in line with his intent to build to build townhouses, not condos. I would suggest in the least that his actions were duplicitous rather than being straightforward and honest. He sought to circumvent existing rules and legitimate consideration of his project. My father always said, when you lie about the small things, you won't hesitate to lie about the big ones. He indicated in his last presentation that he would fix the sidewalks in front of Costa Verano. Truth of the matter is, they didn't need fixing. They were already fixed. The city did that for us, and also instituted a stormwater management for us. So I'm deeply appreciative of that. He also complained at the last meeting that he required to spend more money on filing documents. Again, as a professional, he knew this was the case when he did it. Generally, these functions are handed, and he also seemed to think that he would be on the hook forever, and that's not true. Generally, these functions are handed over to the owners after a majority of the units have been sold. While the phrase that his building would be in the same footprint was parroted monotonously throughout the last meeting, that is not what concerns me. It is the form of ownership that is pivotal to my concern. As a condo owner, I know what enhances the value of my property is the ability to have funds and insurance to recover from major hurricanes in a timely and complete manner, enjoy timely maintenance of the common areas, uniformity of the exterior, and reasonable documents to live in harmony with my fellow condo owners. Townhouses, as proposed by the applicant, offer none of these securities, which in large part will allow the individual owners to paint and modify their dwellings as they see fit. Maintain them or not, they could allow the lawns to be overgrown, they could install ugly landscaping. And I have lived through Hurricane Matthew and watched as a neighboring apartment, non-condo, waited for 2 years to finally get the necessary funds to correct the damages done by that hurricane. I also lost my car in that hurricane.
Mr. Yuri, your 3 minutes are
And that's it. I'm good.
No further speaker cards. We have,
I should also, I'd like to mention that the board was given a copy of your letter, so even though you were not able to read it in the full 3 minutes, we do have a copy of, I believe, the letter that you were speaking from, and I think the same can be said of the speaker prior. I believe that was included in the board.
The president's letter was, but I can include my letter.
If one more speaker. It looks like we've got one other individual filling out a speaker card, but if there are any other items that the members of the public wish to share with the board, they should be submitted through the clerk. But if you submit them to the clerk, we'll have to keep them. You won't get those back, but you're welcome to submit them to the clerk.
No?
Sure. Okay, is there anyone in the audience who has not filled out a speaker's card that wishes to speak?
Can I make one other comment, just for one statement?
It's our policy to limit public speakers to the 3 minutes. That's our board policy. After we've heard everybody speak, if the board has a consensus that we'd like to have people speak for a second time, we can discuss that then, but let's read the...
Just one comment.
Ms. Carlton? I'm sorry, I can't read your first name.
Sorry, quickly. Yeah,
Okay, sorry.
Please raise your right hand. Do you swear or affirm that the testimony about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address for the record.
Yeah, L. Carlton, 2912 Apico Lane, Jacksonville, Florida, 32250. Sorry, I'm a little nervous because I wasn't going to talk, and I just kind of felt the need to speak up as a fellow citizen of Jack's Beach. I'd like everyone to take a step back and look at what is being decided tonight. This shouldn't be personal. It should be decided subjectively and with compassion for our fellow citizens. We are all here in Jack's Beach, and we want what's best for the city. In my opinion, the original variance request itself was confusing. It seemed that the opposing citizens thought that the outcome of the meeting would modify the building structure by either halting the project itself or changing the footprint of the structure. And I don't believe that was what was really being asked for the results. I'm aware that it's important to you that the neighbors do have sometimes give their impression of the variance request, but they seemed misinformed in the last meeting, misused the vocabulary of the zoning land use, etc. And a decision seemed to be made quickly, and maybe there wasn't a complete understanding of really what was requested. It seemed that the opposing group was more upset about the fact that it was built, blocking whatever view the land had, or haven't, and did not understand the difference between the multifamily housing versus a townhouse versus a condo, and just seemed to just oppose it all. There must be an undue hardship for the applicant, otherwise we wouldn't be here. And there doesn't seem to be, from my understanding, any undue hardship for the city or its neighbors if the property is zoned as a townhouse. The request is not the first of its kind. There doesn't seem to be a true reason other than a reason that has become more personal. The way in which a variance is filed should have no bearings on whether a variance is actually approved or not, in my opinion. And I believe that what is being judged is not really the true request. So thank you for listening.
Thank you. Thanks. Any speaker reports? Are there any other letters to be read tonight?
Yes, there's one letter. It's on letterhead from Costa, Verano Condominium Association, dated July 8th, 2022. Ladies and gentlemen, on behalf of the 100 immediate adjacent property owners to 22 10th Avenue South, who are members of Costa Verano Condominium Association, Inc., located at 1031 First Street South, Jacksonville Beach, Florida, 32250, whose combined property value is approximately $150 million. Costa Verano Condominium Association, Costa Verano, objects to the request for relief and variance request filed by Oceanfront 10th LLC, the developer, for the following reasons. One, changing the clarification of the property from condominium to townhomes presents a huge public safety risk that a surfside catastrophe could occur in the future. This is because a townhouse development would not be subject to the requirements of recently enacted legislation, which require condominiums of at least 3 stories near the ocean to have periodic structural inspections, and to fund reserves for structural repairs and other major required maintenance in order to prevent such disasters.
You just read 5 minutes ago, word for word?
No, it's a different letter.
It's sent by a different person.
It is identical to what the letter she got up here read.
It's
I apologize for that.
It's part of the public record, and the public has a right to hear what was submitted to the board.
2, the developer initially applied for a building permit for the condominiums. This afforded the developer a much more lenient, narrow setback of 10 feet on the rear side of the building, which is adjacent to the Costa Verano property, rather than a 30-foot setback they had applied for a permit for townhouses and a 13-foot front setback as compared to 20 feet for a townhome development. 3, now that construction is well underway, the developer is attempting to have the property reclassified as a townhome. This is obviously a deliberate and deceitful attempt to circumvent the permitting process, and the developer's request for relief should be denied on that basis alone. 4, by this deliberate circumvention of the permitting process, the due process rights of Costa Verano's 100 property owners to object to the narrower setbacks have been denied. 5, if a permit had been originally applied as the townhome project with a variance setback for 10 feet in the back and 13 feet in the front, Costa Verano and its homeowners would have vigorously objected to the variance, since the views of the beach and our ocean and many of our owners are obstructed by these narrow setbacks. This diminishes many of our owners' property values. 6, the development of 22 10th Avenue South is between 2 of the highest priced condominiums in Jacksonville Beach, Costa Verano and Maribella. Rezoning the development as a townhouse could negatively affect property values of Costa Verano's 100 homeowners. A condominium is more appropriate for the development at 22 10th Avenue South because the condominium statutes provide for more uniform and a higher maintenance standard by requiring the association to insure the building and maintain the common elements for the entire development. In single-family townhouse developments, each owner is responsible for insuring and maintaining their own individual townhouse, including the exterior and common elements. That would be the responsibility of the condominium association. It is obvious that the developer is planning to shift most of the responsibility that it would be borne by a condominium association to individual homeowners, as his real estate listings reflect a homeowner's fee of only $500 per month, which is substantially lower than the amount that would be required to insure and properly maintain the property as a condominium. The developer cites an additional legal expense required to establish the development as a condominium association as opposed to a townhouse development. However, based on the estimates from an attorney who specializes in HOA and condo association law, the cost differential is only about $5,000, which is a negligible amount for a project that is advertised at a market value of over $15 million. We believe that the real reason the developer is requesting a change in classification from condominium to a townhouse development is so he can keep the homeowner's assessments as low as possible in order to maximize the sales price of the units. 8, finally, in our opinion, the variance application does not meet the required standards under Land Development Code 34-286 because the developer did not show that there were special or unique circumstances or that the developer would suffer an unnecessary and undue hardship. It could not otherwise enjoy any reasonable use of property as a condominium. We appreciate the Board of Adjustment's consideration of these factors and strongly object to the request for relief on behalf of the 100 adjacent property owners at Costa Verano. Respectfully submitted, Costa Verano Condominium Association's Board of Directors, signed R. Travis Story, President.
Thank you. Are there any other letters?
No other letters.
Is there anyone in the audience who has not filled out a speaker's card who wishes to speak at this time? Okay.
Can I make one? It's very personal.
I would recommend personally to the board, we have now heard from 3 members of Costa Verano. I don't think it's appropriate to let a speaker come forward. Again, just as a matter of procedure, is there a consensus of that or a consensus to the opposite?
I concur.
Okay. Hearing no new speakers from the audience, I will now close the public hearing. Or I apologize. We'll allow the applicant to respond to any of the comments made in public comment.
Thank you very much. I'll be brief. And then again, I'm just going to refer you to the Special Master Report. There's nothing that's been stated by the public tonight that wasn't stated in the original hearing held back in January. And if you look at the Special Master's Report, he specifically says the objectors' objections were all either misplaced, irrelevant, or speculative. And nothing has changed. They're still all misplaced, irrelevant, or speculative. I also note that on page 18 of the report, that Special Master specifically said, as noted above, and by the chair at the original hearing, the timing of the applicant or change, as she described it, is irrelevant to whether the variance should have been granted because the timing of the application is not a factor under the Land Development Code section 34-286. It simply is not. It's not a factor. It's nothing to consider. They keep arguing about the same thing, about misrepresented deceit, as this board has recognized, or at least the chair and Special Master, that is not a factor to be considered. Now, the city gets up here and basically argues the same thing, and like this was a foregone conclusion, none of the criteria met. I just remind the board, at the original hearing, it was a hotly contested 3-2 decision. Then we have Special Master, who spent 50 hours reviewing this, who has special expertise, who's done many of these things, and the special master sided with the applicant. So at best, we have a 3-3 at this point. And what the city is asking you to do is substitute your judgments for the special master, who has the training, the experience, and spent countless hours going over every one of these arguments in detail, comparing it to the statute, comparing it to the code, and he rejected these arguments by the city. And now the city doesn't like it. So they're up here telling you, no, you should listen to that. He doesn't know what he's talking about. Well, I submit that Mr. Schmidt does. He knows exactly what he's talking about. And I'm not going to go through all the detail with you, but I would appreciate if you would look at page 20 and 21 of Mr. Schmidt's report. He goes through every single criteria that was necessary under the code to establish a variance, and in detail states why the applicant has met each one of those considerations. And then the last thing I will say, the other argument in here that condominiums are somehow so much more protected and have so much better laws, we offered to the city to put deeds and restrictions in the records that would govern these units just as strict as any condo association, and they rejected that. So we have offered to make these just as stringently regulated as condominiums, and the city doesn't want that. And just the final, as noted in this report, this condo, whether they build it as a condo or a townhome, it has zero effect on the city, the neighboring properties. And there's another quote in here from the special master, if I can find it real quick. I wanted to put it in here about the fact that, if it's a condo, it faces one direction, or if it is a townhome, it faces another direction. But he says, as a practical matter, the way they're built, they're all going to be facing as if they were townhomes, because that's the way they're being built. And it's silly to take an issue with that, is essentially what the special master said. So, as I said before, the development order wasn't based on a proper analysis. The staff report was unreasonable and unfairly burdens the owner's property, and we're requesting that you grant the variance, that you accept this very well-reasoned, objective recommendation of the board. And I thank you to be here.
And while the applicant's making his way up here, I don't know if this is a question for Christian or one of the city representatives, but is it appropriate at this time for the board to ask the applicant questions?
I mean, I don't think so.
That's what, normally we would have done. Go ahead.
Just real quick, to Ms. Durden's point, she talked about, that we would be, basically going against the codes, the LDC land development. This is page 506 from RM2. It includes townhomes. Townhomes is an absolute allowable use contained in that, underneath that zoning designation and that overlay. We're just trying to access those entitlements. She, ironically, many times have been before this board and people have raised the economic issue, and quickly that gets swatted down, but the city presents it as almost a club to mitigate what our request is to hold us down. So I would say the economic relevancy of how the project turns out really isn't applicable. Candor, the market's changing. I've got a stigma on my project right now as we continue to engage in this contentious back and forth of what's it going to be. There is no surety of economic gain, and I don't think that should be considered in any way, shape, or form. The sole relevancy before you and the board, and I think Mr. Kelson spoke to your point, Mrs. Ellis, is the initial application that came before you and what the special magistrate's report is. Obviously, me as a developer, I know that, should I be granted experience, it's incumbent upon me to still go through the planning process through city council, to make whatever fire code or building modifications by the jurisdictional authorities should be required. But what's before you today is, can I do it or can I? And will you support that request? To Costa, Verano. I've completed a townhome project in Jacksonville Beach, channel-side townhomes. We did the covenants and restrictions, they're managed, they're maintained, there's continuity of paint color, etc. And Ms. Durden's capacity as a city attorney for the city of Atlantic Beach, I developed and completed the Atlantic Beach townhomes right behind Ragtime, 12 units. Ms. Durden successfully negotiated with Mr. Van Roy covenants and restrictions that mirrored that of a condo. Me as a developer, I have to provide surety of longevity to the end user. Termite bond underneath the whole building, exterior maintenance by the association, exterior insurance by the association. So we can do those things through covenants and restrictions to shore up whatever concerns any of the neighbors may have. We offered that early on in the process, and we would do that regardless, because we would want to protect the asset. We would incorporate those covenants and restrictions on our own. We don't need to do it as a negotiating tactic or as a concession. If these are townhomes, we're going to incorporate stringent covenants and restrictions because we have a responsibility to our end user, and we want the project to represent quality for years to come. That's the type of project that's being developed. Never was it a ask for forgiveness from me. I communicated to the head building official, I communicated to the fire marshal, I communicated to the director of public works, all prior to building permit issuance. They knew that I was going to submit I want to get this permit, and then I want to submit for a variance. During the mediation, we requested that those three, or the special magistrate hearing, I requested that those three people be available to come in and make a representation. Yeah, we were aware of it. It wasn't a bait and switch. There was no any of that. And we were denied access to those people, even though they were here in the building during that day. Those things are somewhat troubling to me. The thing for me that's the pure form of ownership, these are 5 units. They're not 200 that are stacked. In the initial hearing, we heard testimony about higher financing costs. There's absolutely higher insurance costs. People talked about Surfside. That building sits on, it's been designed by professional engineers. It's been reviewed by city officials. We've hired private inspectors as surety. Me as a developer, when I could have built a wood structure, I didn't. I elected to make it all concrete and steel with wood interior framing. It sits on 87 piles that are 18 inches around, 30 feet in the ground, and it's got a solid concrete structure with solid porcelain walls. I don't, risk mitigation and construction means and methods, there's no shortcuts being taken there. Everything is, highest and best, and what's our best means and application. So for any of those folks that have concerns about that, I would, wouldn't give those a lot of weight and provide them surety that, we're working hard to address those things. The Costa home is, again, economic. It's not a Surfside thing. We can absolutely address whatever concerns they have regarding an HOA through our own covenants and restriction. And again, we would do that on our own anyway, just to make sure that the project was successful. They've mentioned timing. This is a late thing. My permit was issued, maybe called the 28th of October. I submitted my variance package on the 2nd of November, or within a couple days thereafter. We're in July. It took me multiple attempts to get past city staff to even come before the board to review this application. Everything we've been told out on time and kicked down the road and kicked down the road and kicked down the road to now we're kind of at this point where we're before you. We've exercised our rights under 7051. It fell how it fell. So based on those factors that are before you currently, I would submit to you to approve it in support of the special magistrate. This is, I just happen to have it in my file. This is a survey that's received City of Jacksonville Beach of the building directly across the street. And it's got the setbacks, which are all greater than what I'm requesting. I just don't candidly, understand it. As I stand before you today, I read the land development code, I look at the zoning maps and overlays, and these are allowable uses. And I think that, there's steps and there's processes and there's times to make those steps, and this scenario has gotten way outside of scope, way out of bounds, and the request before you is very simply put, it's front rear yard setbacks. The building doesn't modify. And then I would ask that you support the special magistrate's recommendation. So with that being said, any questions? Joe, do you want to? Okay.
I do have one question for you.
Yes, sir.
And this regards criteria number 2. So criteria number 2 was the criteria mentioned in the motion to deny your variance request. That was that's the subject of this hearing today, right?
Special circumstances and conditions do not result from the actions of the applicant.
Yes. So I'm looking at page 20, the bottom of page.
Yes, sir. Yes, sir.
Okay. So the city argues that, so as you can see, the special magistrate says that the condition, the lot's narrow width, is not a special condition that you created, right?
Correct.
The city argues that when it was being developed as a condominium, that you didn't need a variance for that. The setbacks were all correct. But that when you requested the variance to construct the townhouse, that you created the condition. And so what I would like you to do, if you can, is address the city's arguments on this criteria number 2. Does that make sense?
Oh, yeah. I think he handles it well, but to add to that, I'm Joe Van Roy, I'm one of the applicant.
Would you continue these program?
It's
With your name and your address to the
Can you
clerk.
please raise your right hand? Do you swear or affirm that the testimony about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Please state your name and your address for the record.
I'm Joe Van Roy, my address is 9471 Bay Meadows Road, Suite 103, Jacksonville, Florida. All right, the lot itself is 66 feet wide. When you, if you go to do townhomes on this lot, when you apply the front rear yard setback, the 30-foot rear setback, the 20-foot front yard setback, and the way they're measured, it ends up with a 16-foot strip of use of the property, and that's the issue. There's really no way to do townhomes other than that, and have them have any functional footprint that complies with code. And I do think that requiring a different ownership style, when we're not looking to stack units, and I think this is maybe not everybody. I'm a state attorney, but training and experience, but not everybody. You do condos because you can stack them. There's units on top of each other. You can't have a legal description that's measured by a surveyor, right? They're a box created by the state of Florida, suspended in the air. Here, this project is designed that it can be you will. There is nothing on top of one another. So all we're talking about is the way that it gets measured is the change. And so yeah, that I think is the hardship, is that, and it's on us, but it's as the applicant, but it's on the future owners going forward. And that was this isn't about the money to us. This has not been an inexpensive process to get here today with the the special magistrate and everything else. It's not a cost saving to us. This is an expense because it ought to be townhomes, because it looks like townhomes, it operates like townhomes, and I don't want to do the ultimate citizens in there wrong by taking the easy path and making it condos. Because if you're not stacking a unit, there's no reason, there's no protections. It's a misnomer that people think they're going to be of higher quality or better cared for. It's 5 units. They're going to be cared for exactly like the 5 owners want to be cared for. I've owned townhomes, I've owned condos, I've been in poorly run condos, I've been in well-run townhomes, and vice versa. You know, and it's up to the owners ultimately. Once we're out of it, we can create the structure, and I'll draft, and I will, and I have done many townhome projects with very aggressive, the association's responsible for the colors, the uniform paint colors, the window glazings, you name it. It's going to look just as good as any condo ever would. And but ultimately, when we're out of it, whether it's a townhome or a condo, it's going to be up to the 5 owners and how they want their property being maintained. Again, there's poorly run condominiums and there's well-run townhomes, and it's up to the owners at the end of the day.
On that same note, I have a question as well about some of the findings in the Magistrates Report, also on page 20. So to Owen's point, the city's arguing that when the variance application was made to change it to townhomes from condos, that the applicant thereby created their own hardship. Let's say I were to differ from that opinion, or not differ from that opinion, but just focus on the actual application for townhomes. In this report, it mentions that 3 townhomes could have been built fronting First Street for either no variance or a very minimal variance. And the magistrate's findings are that the units would only be 15 feet wide and the middle townhouse would have no windows. And while I understand aesthetically that's not ideal for a buyer, I don't know that that's necessarily in conflict with the minimum size for a home or a townhome by code. So if you set aside the fact that the applicant may or may not have created his own hardship by switching the property from a condo to a townhome, how would you address the fact that the applicant may have created their own hardship in choosing to build the units oriented the way that he did versus the way that the city has suggested he could have fronting First Street?
I think that's an unreasonable concept to run with. That middle unit, okay, by the time you build the walls, in a townhome you have a thicker wall than normal because they're in a single family home or what have you, because of the noise mitigation that you need and fire codes. You have less than 14-foot interior space, 160 feet long. 100, to use this site reasonably, there'd be a walk-through bedrooms, and I guess you couldn't do that. You can't do that. You can't have a linear product like that in a meat fire code, for instance, for ingress and egress for bedrooms. It's just not a reasonable. It's like he found. It's not a reasonable use. It's that itself would be it's a fabrication really that doesn't exist. That nobody would do that in this instance.
Is it, if it's okay, could I ask the city to address that? Because I do want to make sure, if I'm considering this finding of the special magistrate, I want to know, is the less than 15-foot wide unit more of a, we prefer not to because what buyers are going to want that, or is it truly a code minimum situation where they legally would not be allowed to put in for example, in RS1, there's a minimum square footage that a home must be? Is there a minimum square footage or width or anything like that for townhomes in this zoning district that this 15-foot wide middle unit might not adhere to? And maybe I should have Mr. Undue address that, or?
Well, I mean, I can speak to the code provision in that the minimum middle unit lot width is 15 feet. And there are developers building these in the city right now. They clearly meet fire code and building codes, they've been permitted. So you could legally do a 15-foot wide unit. The minimum unit size for townhomes is 700 square feet for a one-bedroom, 900 square feet for a two-bedroom, or 1,100 square feet for a three-bedroom. So as long as they can meet those minimum sizes for the number of bedrooms, they can legally build a 15-foot wide townhome without any relief from us.
And does anybody know if those minimums would be able to be met without a variance if they were fronting First Street?
Yes, we actually mapped that out, and it's entirely possible to do 3 units with the middle unit being 15 feet wide.
At the minimum, and meeting the minimum square footage?
Mm-hmm. Again, they're doing this in the city right now.
Thank you very much. Can you hear me? Yes. Okay, good. A couple things. First, he can do the townhouses without the variance. We went through an extensive exercise to describe and show how the 3 townhouses could be built on this property. I hear in the background people saying, yeah, but it's 151 feet long. The townhouse doesn't have to be 151 feet. Yes, the lot that the townhouse is on will be 151 feet because it will stretch all the way to the ocean. But quite frankly, if I might say, people might enjoy being able to look directly on their property out at the ocean as opposed to, looking at a street, for instance. So, in other words, just because the lot is 151 feet long doesn't mean that the townhouse itself has to be 151 feet. It can be very reasonable depth. Number 2 is that we know in our city that there are a number of townhouse developments with these 15-foot wide lots that have been approved, been platted appropriately, and exist and are going forward. The issue about the no doors or windows that the special magistrate mentions on page 20, I was shocked to see that in the report, considering that he makes a big deal about, well, that wouldn't be very good, except that we have 5 condos that are being proposed, that have currently under construction, 3 of which clearly have no side windows or doors. It's only the end unit. So to me, it's a facetious and irrelevant comment. And then 2 other points I want to make about the report, because I think you do raise a good question. That drawing out, after you look at the last paragraph on page 20 and then the first paragraph on 21, the special magistrate says, and if the lot's narrow width is a special condition which justifies consideration for a variance, that condition did not result from the actions of the applicant. On the next page, it says similarly, if the narrow lot is a special condition that did not result from the actions of the applicant, then the granting of the variance would not have conferred upon the applicant any special privilege. I think the key word in those 2 sentences is the word if. And when you look back to the rationale that is used here to justify, the width being the special condition, it's based on the idea that he has an absolute right to do townhouses. And that's not the case. He doesn't have an absolute right. You hear, I even heard Mr. Van Roy say, you know, it's not reasonable for us to have to, you know, it's not reasonable for us not to be able to do townhouses. Well, number one, he can do townhouses. It's just not as many as he wants to do. And number two, it's not that he has an absolute right just because townhouses are listed in the list of permitted uses. You still have to comply with the code requirements. So to me, it comes back to this issue about how did we get here? And we got here because Oceanfront chose to lay a footprint on the ground, start construction. There was no opportunity for modifying or changing that. The building was already halfway up. The walls were halfway up, maybe taller. I can't remember. I mean, the fact is that there was no movement, no opportunity, because he chose to lay the foundation where it was. And it goes to the undue burden argument here. Was there an undue burden on the owner's use of the property? And clearly not, in the sense that this is what he chose, and you can see that he has many uses, but he chose this particular use, and he chose this particular footprint. It comes back to the issue of why do we need this particular variance? Because he chose to build the footprint where it's located. And it comes back to your criteria, and why your criteria is the main thing, and the main reason that we don't believe that this Special Magistrates Report is correct. And it also goes to the issue of why you should reject and stick with your let your original decision remain unchanged. I'd be happy to answer any questions if you have any.
I have a question regarding criteria 5. Grant of variance is the minimum variance that will make the reasonable use of the parcel of land, building, or structure. And I suppose it also somewhat addresses criteria 4, literal interpretation and enforcement of the terms and provisions of this code which deprive the applicant of rights commonly enjoyed by other parcels of land and work unnecessary and undue hardship. I guess it really addresses criteria 5 more so. So my question is, again, referencing what the Vice Chair initially brought up, and your comment about the applicant's right to build a townhome. So the applicant can, trying to figure out how to phrase this. So I guess your argument is, the city's argument is that he can build what he wants to build. Literal interpretation of the code doesn't deprive him of those rights because he can build a condo. He doesn't have to build a townhome. He can build a condo to the same specs that he's building on right now, to your point. However, is that code applicable based on the fact that there's other uses for the property, or can it be applied more narrowly to the use that the applicant has chosen?
May I make the code?
Yes.
You know,
I probably could be more eloquent, but I guess what I'm wondering is, typically when we hear variances, I would say the majority of them are for single-family homes, and we have to look at, is the code depriving the applicant of, developing the property based on, commonly enjoyed rights. But I don't think that at least I haven't had to factor in a situation where there were two potential uses. And I'm struggling to see whether we can hold the applicant to the standard based on the usage that they're choosing. I'm probably sounding even worse. I don't know if that makes any sense. The literal interpretation and enforcement of the code can be applied to the condo, and there are basically no issues. But is the applicant limited only to developing the property with a usage that creates no issues, even if townhomes are allowed to be developed in that zoning district?
He had every right to come in and ask for the variance. So that's what he would have, in order to do the development as a townhome, there's no denying that he had a right to come in and ask for a variance. But if he doesn't get the variance, then he can't do that particular development, that particular footprint as a townhouse development.
Okay.
In other words, going to your, I think, your question is, do we, when I said he doesn't have an absolute right to do these townhouses within the footprint that he's chosen, and he's put in stone, literally put in stone, he has to get the variance, and the variance has to meet the criteria. That's this board's responsibility and obligation, is to determine based upon the evidence that's presented to you whether or not he meets their criteria. So that's when I say he doesn't have an absolute right unless his property meets the code. Just like he came in with the condo project, he had a right to do that. The city had no basis at all to say you can't do a condo project there, because he met all the code requirements. So the code requirements are the things that establish the, what you can do on a particular piece of property. Now, if you don't meet all the code requirements, nobody's ever said to Oceanfront, oh, you can't come in and ask for a variance. That, he has that right, but he doesn't have an absolute right to obtain that variance if he doesn't meet the criteria. I hope that answers.
Thank you.
If I could ask, I think the question is for each type of usage for this property, should they have the ability to build a piece of property, a building that for each use, a reasonable building for each use? Or is it just any use amongst the choices?
Right. Remember, the test is there a reasonable use to be made of the property? It's not
For each type of,
right.
Is it for
And,
each?
and in some cases, a piece of property may not qualify. It may not qualify, so you have to come in and ask for a variance. But a variance is not guaranteed at all. So you could have 20 different uses listed under RM2, and we probably do, right? And if you are on you come in and you say, I want 5, right? He wants 5 townhouses. Well, the piece of property doesn't qualify for 5 unless you come in and ask for a variance, and you may not get your variance. But in our case, we know that he could have 3, even townhouses. He could have 3. So, the whole focus on whether it's reasonable to have 3 or whether it's unreasonable to say you can't have 5 is not really the test. The test is, does your property, is there something peculiar about your property? A parcel that's 65 feet wide and 100 and whatever feet deep is not peculiar. There's nothing peculiar about it. So from that perspective, I would say that, I hope I answered your question. You know, not every single use necessarily will result in a right to develop a particular use that's listed in that. It all depends upon the piece of property, where you want to put it. It depends upon the zoning that's on that piece of property. It depends upon, you know, all the things that are listed, the standard lot size, setbacks, lot coverage, all of those things that are in your standard code would apply to any of those uses that are outlined. I hope I answered your question.
I have one more question. I'm just curious why we're talking about 3 and not 2. I mean, if it's going to be so tight for 3, why are we talking about 2? I mean, if it fits within the
Because we were asked what would be the maximum, we were asked what would be the maximum number of townhouses he could have on the property without a variance. That's why we talked about
Through
it.
the chair, the definition of townhome requires 3 units.
Okay, that's what I was wondering.
Oh, okay.
And
That's
Correct, and
that's
then
what I was wondering. Okay.
maximum of 6 before you have to have a separate building.
Does anybody have any other questions of Mr. It appears as though the applicant would like to address some of the comments. Any other questions for Mr. at this time?
Thank you.
Thank you. Comparable products. The Sturgeon speaks about the city and 15-foot product. During the special magistrate procedure and they're promoting the 3 townhomes, they made their presentation. There was currently 15-foot platted lots in the city of Jacksonville Beach. We asked for copies of those plats and we asked if there were any variances that had been applied for any of those products. They were on 9th Street, 10th Street, low-income housing, approximately 50 feet deep, 15 foot wide, 15 foot deep. They did get a variance on one of the parcels so they could accommodate more density. This is, you presented the issue, ma'am. This is not low-income housing, this is oceanfront. As the resident said, it's between 2 of the highest income properties in Jacksonville Beach. Highest and best use, which the city speaks to as it relates to a condo, or it could be increased density. One important distinction, we keep talking it's a condo, it's a condo, it's a condo. It could also be a multi-family building. It could be a for-rent product. We could do different things with the existing footprint. The boot is on the ground, the boot is set, but for a practical matter, the project was designed duplicatively, contemplating this request for variance at a later date. From a practical standpoint, the 4 front doors are on 10. The address for the project is on 10. 1 unit dumps on First, and that's the western unit. Another kind of example would be when somebody builds a mixed-use building, they don't know what the tenant mix is going to be, and the tenant mix for an esthetician is going to, the permitting requirement is going to be somewhat different than the permitting requirement for a restaurant or a small retail shop. So those distinctions, I don't know. I think it's got some relevancy. This plat was done in 1909, and since 1909, the city has adopted a comprehensive plan, amendments, land use code, development code changes that the land is older than those. And so they're overlaying these amendments on top of the land. It's no different than the land development code says an RS1 mod is 10,000 square feet. There's not a lot of those in the city of Jacksonville Beach.
Did you say 1909
1909, yes, sir.
was when it was planted?
Yes, sir.
110 years ago.
Yes, sir. So that in itself, and let's talk about unnecessary and undue. The mere representation, designation by parties other than me, the owner of the property, and what I want to do with it is an unnecessary and undue hardship. To put it in a box and say this is all it can be because we said so, That's unnecessary and undue, and in itself is improper. Does it differ for a request for a pool or a request for an accessory structure? Is it materially different what we're asking? I'd like to think not. I mean, ideally, the request stands on all fours. We cannot use the land the way that we would like to use the land with our current building and make it townhomes without this variance. And we went through the process, and we're flying under the special magistrates report and hope that this hearing has been insightful and you guys find it in our favor, and we can hopefully move past this. Any questions for me? Thank you.
Any other questions for the city? And I will now close the public hearing and bring the item back to the board for discussion. And before a motion is made, I guess, Christian, point of order, do we make a motion in this case whether to approve, modify, or reject the special magistrate's findings? That's the,
So
one of those three is.
I'll defer to the attorneys for a definite answer, but my understanding is you can do those three things or choose to do nothing.
And it requires a 3-2 vote or a 4-1 vote.
Let's let the,
To answer Mr. Moreland's question first, it's a majority vote,
simple majority.
simple majority. Yes, I would say that this board would make a motion. Your options are a motion to accept the special magistrate's report. In that event, if that motion were to be approved, then you would also then need to go back and actually vote to approve the variance. A second option is to reject the report. In that instance, no other action is necessary. If that motion is approved, then that allows your January 19th, 2022 decision to remain unchanged. Number 3, if there was some middle ground modification that you want to make, you could modify the vote. You could make a motion to modify the special magistrate's report with some condition associated and being a part of that motion.
And would that address the initial variance request itself, or does it not, does it just sort
It
of
would
address
become
the-
a condition, it would be, if you had a condition in mind, then it would be to, basically, you'd be adding a condition, you'd be voting to approve the variance with some kind of condition or modification. And then number 4, of course, by statute, this board doesn't have to take any action at all. And if you choose to not take any action at all, it constitutes a rejection of the special magistrate's report, and your decision of January 19th would remain unchanged. So, I hope that helps.
I just want to add to this because you have a statute in front of you. You have it. I gave it to you. It is section 21, 70.51. It doesn't address making motions. What it says is you can, 1, accept the recommendation of the special magistrate as submitted and proceed to implement it when appropriate. Then it says, B, you can modify the recommendation as submitted and proceed to implement it by development agreement when appropriate or by another method. you can reject the recommendation as submitted. And then it does say, failure to act within 45 days is a rejection. So really, it gives you three options. I guess if you don't want to rule and you don't want to do anything for 45 days, it would act as a rejection. But it's not like a choice. Don't worry. But anyhow,
Actually,
it's stated right there in the statute.
Thank you. I think I stand by. In order for you to accept, to rule on it, you have to make a motion. So I don't understand how this board could act without making a motion and voting. So,
I don't want to come back and do this again. I'm going to make a motion.
So is there a motion?
I make a motion. I move to reject the special magistrate's report and recommendation in the section 70.51 Florida statutes, proceeding initiated by Oceanfront at 10th LLC, following the City of Jacksonville Beach's Board of Adjustments denial of its application for a variance, City BOA number 21-100193.
Second.
It's been moved and seconded. Any discussion?
Yes.
I go back to the comment, it doesn't change anything.
Yeah,
Everything we do on this board changes. Everything has an effect. And then even the case brought forward, this has past president brought into the subject matter of past president activity. So I do concern myself with that. And the second comment I have is it doesn't change anything. There's still a mailbox, there's still a driveway, there's still some building inside. It does not change anything in that aspect of denying rights. It's initial thoughts.
I keep going back to criteria number 2, which is what this board based this decision on, and how different the arguments are. The city argues what the board had accepted, I thought, as criteria number 2, which is that in deciding to change from condominium to townhouse, that was an action of the applicant. The special magistrate says, no, it's the narrow width of the lot, and that's not the applicant's fault. I mean, that's not his, it's not a condition that resulted from the actions of the applicant. So my question to both sides, which got answered somewhat roundabout, goes back to what I think was the basis of our original decision, which is that the applicant told us he's going to build this building, and that that it didn't matter, that it didn't matter. So then it's his actions, it's the condition, which the condition of asking for the variance creates the issue, and that is the action. Yeah.
And I would actually, I came to the same conclusion, but I think by a different route. I wouldn't necessarily say that just by nature of him asking for the variance, he created the hardship, and that is what my very awkwardly worded question was getting at. And as I stated in the January meeting, and as is in the special magistrate's report, I don't think it's, it was not up for this board to decide whether the actions of the applicant were duplicitous in any way. The fact of the matter was, it was a variance request that came before us. However, I think that what is actually the result of the applicant, as Ms. Durden pointed out, is the fact that he began building, which essentially locked him into this floor plan. I would have no issue having approved the variance for townhomes of another kind on this property. 2, 3 units, whatever the case may have been, if the variance requests were reasonable based on the specifications of the property. But I think that Ms. Durden made a really compelling point in saying that once that foundation was laid and this was the only building that the developer was willing or able to build on this property, then that did result, then the hardship does now result in his own actions.
I would just add one other thing, and that is the decision to switch from condominium to townhouse. I've never assigned a nefarious reason for that, and I think that the special magistrate takes issue with that in a harsh way that we didn't even consider. So it's assigning an adverse judgment that we didn't render. And likewise, we didn't consider value or use and those arguments, which are expounded on, except for ad nauseam in this.
Well, I think that was probably to address the very impassioned public comment, because that was what most of the public comment addressed. So, and public comment obviously does, we factor that in as well, but in that specific case, I don't think that, at least I personally didn't factor that in when I made my decision. And in fact, when I initially made my decision, I was in the minority that voted in the applicant's favor, but in light of the arguments made tonight, I just can't get past the fact of criteria number 2, in that he can't do anything else with the property at this point because he began construction on these certain specs that did not meet the land development code and are frankly unreasonable to ask for a variance for, in my opinion.
I agree.
And I will go along. I was the other guest spoke originally. And in retrospect, given how many hours I spent on this at home the last 2 days trying to understand it, my understanding of the issues was not nearly as sharp as it is tonight.
Yes.
And I intend to vote in favor of the motion.
Is there any other discussion? Okay. Hearing none, can we have a roll call vote, please?
John Moreland,
Yes.
Owen Curley,
Yes.
Jeff Trular,
Yes.
Todd Smith,
Yes.
Alexi Gonzalez.
Yes. The board has voted to reject the findings of the special magistrate. The next agenda item is the planning department report.
Just a reminder, your next meeting is actually next Tuesday. We have 4 cases, but otherwise, it's the only thing I have.
We do have currency of the board visitors on the agenda tonight. Our visitors are making their way out, so is there a motion to adjourn?
Oh, wait, oh, sorry. I just wanted to ask if I could please get the handouts. There was several handouts, there's only one copy of. Thank you.
So was there a motion to adjourn?
Move to adjourn.
All in favor? Aye. We adjourn.